And I remembered to hit the right button. I'm pleased that this virtual meeting format has allowed so many of you to join this meeting. This is the second in a series of scheduled meetings. The meeting schedule is available on the National NAGPRA Program events page, and I'll put a link in the meeting chat. Before we begin, I would like to remind everyone that this meeting is being recorded. The recording, transcripts, and meeting minutes will be made publicly available after the meeting and will include the names of all of those in attendance during today's call. If you object to this in any way, you may disconnect at this time. This is a meeting of the Federal Advisory Committee established by the Native American Graves Protection and Repatriation Act, or NAGPRA, of 1990. And this meeting is regulated by the Federal Advisory Committee Act, or FACA, and its implementing regulations. This meeting was noticed in the Federal Register on December 10th, 2021. An agenda for this meeting, as well as meeting materials, are posted to the NAGPRA program events page. And again, the link is in the chat. The FACA charter governs the objectives and scope of activities for this committee. The purpose of the review committee is to monitor and review the implementation of the inventory and identification process, as well as repatriation activities under sections 5, 6, and 7 of NAGPRA. The review committee is also responsible for reporting to Congress on the progress and any barriers encountered in carrying out its responsibilities. With that as a brief introduction, I'd like to start with a roll call of the committee members. Please respond out loud. John Beaver.
Present.
Honor Keeler.
Present.
Barnaby Lewis.
Here.
Timothy McEwen.
Present.
Frank McManaman.
Present.
Shelby Tisdale.
Present.
Currently, the review committee only has 6 appointed members. The charter for the review committee does not contain a quorum requirement and a meeting may be held with fewer than 7 members present. FACA does require that the committee membership be fairly balanced in terms of points of view represented and functions to be performed. As the designated federal official for this committee, I've determined that this meeting may proceed with only 6 members. Frank McManaman was selected as the chair for this committee. Mr. Chair, I hereby call this meeting to order.
Yes, Madam DFO. So we consider the meeting to be in order.
Would you like to start with a traditional opening today, Mr.
Yes,
Chair?
please. Barnaby Lewis has graciously agreed to do a traditional prayer for us. Thank you, Barnaby.
I want to start the meeting with the mayor asking the Creator to be with us as we discuss the various matters related to our responsibilities, and it really affects and really central to tribe's concerns regarding return of ancestors and their belongings. And as you know, I do this in the language that a Creator gave us, taught them language, and also do it without my video. Nada que matidade idem tax. Itanya givum that apachada that numa pick. So much what do non-commanded what comes non-commanded all come. If you mapako it's a doing you back here that governor Tanya which is one to start it with wood much like tree. It's much not a quite joke or shooting. Shoot it's with why to stick the guitars and hold them. Big mess number some did what's not go another go for my wapa. But we quick madam did but not go sap butch open my kids. Makitanya give up the capital that push the key but you joke your time. Push the key but what you quite don't why sap with me that sappy dark be here that tam did about joke I would. I give Kahuga. I hear them a small material about the team and thing. Bruce read them at the core type, but I didn't word it. Bruce read them at my type, who come a word. Supper. Thank you.
Thank you. Before we begin our first item, I would like to acknowledge the individuals who are assisting me today in conducting this meeting. With me are two attorneys from the Department of the Interior, Office of the Solicitor, Brady Blasco with the Division of Parks and Wildlife, and Stephen Simpson with the Division of Indian Affairs. Other members of the National NAGPRA program staff are also in attendance today. Lisa Koszalski is the review committee coordinator who is responsible for organizing this meeting, as well as preparing minutes and transcripts of these proceedings. I greatly appreciate the support of the rest of the program staff, as well as others within the Department of the Interior who have assisted me in preparing for this meeting today. And a big thank you to all of you who are joining us today. Please note that the review committee is very interested in receiving comments on progress made and barriers encountered in implementing NAGPRA. If you're interested in providing a public comment during this meeting or at future meetings, you can let me know when I ask for public comment. At that time, you will be able to submit a question or your name in the chat or raise your hand. Or you may email me to make your request, and I'll put my email address in the chat. It's nagpra_info@nps.gov. Mr. Chair, the first item on the agenda today is a presentation from Margaret Bradley, the ethics specialist for the National Park Service with the Ethics Office in the Office of the Solicitor in the Department of the Interior. Ms. Bradley is with us today to provide a presentation on the ethics requirements for members of this committee. As a reminder, members of the review committee are appointed by the secretary and serve as special government employees. With this appointment, members of this committee are required to adhere to some of the ethics responsibilities of all federal employees and must receive regular ethics training. For those of you who are in the audience today, this presentation is not usually a part of our public meetings of the review committee. Generally, the review committee completes this requirement during administrative or preparatory meetings. However, due to this virtual setting, as well as the series of scheduled meetings, it was more convenient for this presentation to be given at this time. Nothing in this presentation is confidential, and therefore the committee chair and I determined that we should add this item to the agenda today. Further ethics trainings may not occur in this public format, but the department will continue to provide this training to committee members to ensure that they are aware of their responsibilities. With that, Ms. Bradley.
Melanie, thank you so much. And members of the review committee, thank you for taking this time to fulfill your ethics obligations through this training. I am going to share my screen so that you can see the presentation. Let me see, that does not, are you seeing the beautiful sunrise and the Department of the Interior logo?
Not yet.
Not yet, okay.
It's
Hopefully you're
there
seeing
we
it.
go. Yep.
Okay, I apologize. Sometimes technology and I are not on the best of terms. Okay. So thank you for serving as special government employees for the NAGPRA Review Committee. It is very important to the Department of the Interior that we have the input of our citizens who help give recommendations and advice to the Secretary of the Interior and the Director of the National Park Service on a variety of important topics. You are instrumental in helping to form government policy and programs through your service, and you very much enhance the department by providing your subject matter expertise to the NAGPRA Review Committee. As a reminder, you were appointed as a special government employee, which means that you are an officer or employee in the executive branch of the federal government, of the executive branch. You are appointed to perform temporary duties, unfortunately in your case without compensation, and for a period not to exceed 130 days during any period of 365 consecutive days. You are legally considered to be federal employees, and this is important because it means that you are subject to the criminal conflict of interest laws. However, they are somewhat less restrictive than they are for regular federal employees like myself. And These ethics rules apply to you primarily because public service is a public trust. And I know we all take that very seriously and want to conduct the work of the review committee with integrity and above reproach. All federal employees, including special government employees, are expected to uphold the highest ethical standards. And this means that your financial or outside interests must not conflict with your duties as a special government employee in order to maintain the public trust. So given the very unique nature of your part-time service, you often have outside employment, outside activities, and personal financial interests that could potentially conflict with your federal role. And so that's what we're going to try to cover today. So my goal today is not to make you experts in the ethics statutes and regulations. It is simply to help raise that little red flag that sometimes waves and says, maybe I should get an ethics opinion on this. If that is the case, I would encourage you to reach out to Melanie and to me, and we will help guide you through any matter to make sure that you navigate it without a violation of one of the conflict of interest laws or one of the regulations. As you know, and many of you have already filed your financial disclosure reports that are due tomorrow. Actually, I gave those who had not yet filed an extension till March 1. That you are required to file your financial disclosure report on an annual basis. And you're required to do so every year of your appointment. If you have any questions or have any difficulty accessing FD Online, I would just ask you to not fight with it and reach out to me. FD Online was written for the easiest use for people with a .gov email address. And if you do not have a .gov email address, I would just ask you to reach out to me. Together we can come up with a workaround and just don't engage in a fight with FD Online, is what I'm saying. Reach out to me and I'll be happy to assist you with that. Also, you're required to undergo annual ethics training. You initially underwent ethics training when you first came on the committee, and now you're required to undergo annual ethics training. This session fulfills that requirement. The Department of the Interior is requiring that you undergo this ethics training prior to giving advice to the government, which is why we are taking care of this at this time. This is the list of the criminal ethics statutes that you're subject to as special government employees. We're going to spend most of our time on 18 USC 208, which is the primary financial conflict of interest statute, but we will go over all of them. So starting first and foremost with 18 USC 201, as you know, as a federal employee or including special government employees, you are prohibited from seeking, accepting, or agreeing to receive anything of value that is given to influence your performance on the review committee. 18 USC 203 prohibits you from receiving compensation for representing another person, a third party, before a federal entity in any specific party matter. Now, I have just used the term specific party matter. When we get to 18 USC 208, I will expand the definition of that and try to give some examples. But just know that for now, when I say the words or the phrase specific party matter, I'm thinking about things like contracts, leases, and grants and permits. So there is a prohibition for you accepting any form of compensation for representing a third party before a federal entity in any specific party matter. 18 USC 205 is similar, but it does not prohibit compensation. It prohibits any type of representation. This would be representing a third party, a non-federal entity, whether or not you are compensated before a federal entity in a specific party matter in which the United States is a party or has a direct and substantial interest. So, for example, perhaps the committee has been working with the university on providing a research grant. And the grant is issued to the university, and now the university asks you, because of your relationship with them, to contact the federal government to renegotiate the terms of the contract. You may not do so. If anybody asks you to represent their interests to the federal government, please give me a call, contact me by email, and we'll look at all the elements of the situation and give you the advice to avoid violating this law. 18 USC 207 is going to affect your post-government employment activities. after your term on the review committee ends. And it does not prohibit who you can work for. What it prohibits, or what it limits, I should say, is representing or communicating on behalf of a third party to any federal entity on any specific party matter, like a contract, in which you participated personally and substantially. I'm not going to worry about the additional 2-year ban that is mentioned here, because that is really referring to people who are supervisors, and none of you are in that role. So again, once you leave federal service, kind of that same scenario I used in 18 USC 205, you participated in a grant review and issuing a grant to a university for a research project. You have your term on the committee has ended. You have been employed by the university, and the university asks you to contact the NAGPRA review committee or any federal entity to renegotiate the terms of that contract. You may not do so. So the National Park Service Ethics Office remains your ethics office after you leave service on the review committee. And I will be happy to answer any questions you have as you approach the end of your term on the review committee or after you leave service. I will still be your ethics official and happy to assist you in those matters. 18 USC 208 is the primary financial conflict of interest statute. And it prohibits you from participating personally and substantially in any particular matter that could directly and predictably affect your financial interests or the financial interests of this list of entities that the law imputes to you. The law counts these financial interests as your own, and that includes the financial interests of your spouse, your minor child, or your general partner, should you have one, an organization in which you serve as officer, director, trustee, general partner, or employee, and a person or organization with whom you are negotiating or have an arrangement concerning prospective employment. And so, of course, as special government employees, the majority of your life takes place outside of the NAGPRA Review Committee. And it's important for you to know that your employer's financial interests are counted as your own. And so if a matter comes before the committee that is going to affect the financial interests of your employer, you need to stop, contact Melanie, and contact me. We will see if all of the elements of the law apply. And if they do, we'll issue a recusal. We'll help you navigate through this, again, so that you can avoid violating a criminal law, and so that the activities of the review committee are carried out with integrity. Another great resource for this is your charter language that governs the review committee. And actually, on this particular slide, I happen to pull the charter language for the NAGPRA Review Committee. And the ethics language there says that no committee member shall participate in any committee or subcommittee deliberations or votes relating to a specific party matter before the department or its bureaus and offices in which the member or the entity the member represents has a direct financial interest. And so I think that the charter language is a little bit easier to follow than the language of the statute. And that's why I put it in there. So I've referred to particular matters and particular matters involving specific parties, or sometimes called a specific party, the specific party matter. 18 USC is really looking at on this slide with the 3 boxes, the middle one and the one farthest to the right. When we think about what are particular matters that might come before the review committee, well, it would be matters of deliberation that the committee is undertaking, and it's focused on a discrete and identifiable class of persons. So for example, a policy or a regulation that is going to affect every American taxpayer is not a particular matter of general applicability. It's covering every taxpayer. It's way too broad. But an example we have here of a particular matter of general applicability that is focused on a discrete and identifiable class of persons might be regulations directed towards oil rig safety. This is going to affect the interests of oil and gas companies, whether they are drilling, exploring, midstream, whatever they may be, or policies that are focusing on interests of federally acknowledged tribes. What we worry mostly about are going to be the particular matters involving specific parties. This is why I find most special government employees on most committees usually are working. But however, I know as a FACA committee, the matters under consideration are much broader than perhaps those of a committee that is engaging in acquiring property or issuing contracts and grants. But when we think about a particular matter involving specific parties, we are thinking about a legal instrument where the parties are identified and their legal rights are affected. And so that's going to be something along the lines of a contract, a litigation, a permit, a lease, an application, things along those lines. And again, if a matter comes before the committee that affects your financial interests, whether it is a broad policy or not broad, but whether it's a policy that is directed on the interests of a discrete and identifiable class of persons, or if it's one of these very narrow particular matters involving specific parties, and it involves your financial interests, please give me a call, notify Melanie. And again, we will apply all the elements of the law to see if it applies to you. And when we talk about financial interest, this is what we're thinking of: your stocks that you may hold, any bonds that you have, interest that you have through ownership, partnership, being a part of a limited liability corporation, and so forth, any consulting arrangements you may have, any grants or contracts that you are involved in, and your outside employment. So when I talk about financial interest, this is what we mean. And so in order to avoid a conflict of interest, you may be required to recuse from a matter. In order to avoid that, I would work with you as the special government employee and with Melanie, and we would put together a recusal that states what you are recused from in what situations. And it may be limited. For example, you may be in the process of selling your home, and someone who has business before the review committee is interested in purchasing it. We would issue your recusal for participating in matters that would affect that entity that's interested in purchasing your home until your home is no longer off the market or the entity has expressed no interest in your home. Recusals are fairly easy to put together, and I would be more than happy to work with you on one. If you think you might need a recusal, again, just contact me. Make sure you do this before working on the matter that is in question or participating in any committee work on the matter. And that's why I'm here. And I'm here to be on your side and assist you to navigate around these laws in a way that avoids the violation. Also, as a reminder, as a special government employee, you are prohibited from acting as an agent of a foreign principal that is defined under the Foreign Agents Representation Act, or to serve as a lobbyist on behalf of a foreign entity that is required to register under the Lobbying Disclosure Act. If anyone does contact you, a foreign principal asks you to serve as a lobbyist or act on their behalf to the federal government, tell them no. Feel free to give me a call. We will be happy to work with you, give you a language on how to interact with them and what is the best course of action for you. So that was an overview of the criminal statutes. Next, I'd like to get into the general principles of ethical conduct for employees of the executive branch, and this includes you as special government employees. And this is kind of a roadmap of what we're going to look at: gifts, impartiality, misuse of position, and outside activities. And so, as you recall from previous training, you are prohibited from accepting a gift that is offered to you as a result of your membership on the committee. You also are prohibited from accepting gifts that are offered by a prohibited source. And a prohibited source is anyone who is seeking official action from the National Park Service, anyone who is doing or seeking to do business with NPS, anyone whose activities are regulated by us, and anyone whose interests are affected by the performance of your official duties as a special government employee. There are some exceptions, and if you are offered a gift, I would encourage you to reach out to me. And again, I'll work with you and see how the regulation applies to that gift. So a gift is anything of value. It could be an invitation to a reception that is offered to you because of your position on the committee. It could be a tangible gift that you are offered. However, I also know that the majority of your life is spent outside of the NAGPRA Review Committee, and that you may be given gifts, honorariums and so forth because of your position or achievements in the private sector and because of your standing in your communities. And I just want to let you know that gifts that are given to you in your private capacity do not raise concerns under the standards of ethical conduct. It is when someone offers you a gift because of your role on the committee or from someone who is seeking official action. That is the standard for determining whether it's acceptable or not. So thinking about impartiality, we looked at the criminal conflict of interest statute 18 USC 208 and discussed that you are prohibited from participating in a particular matter that will directly and predictably affect your financial interests. Sometimes there can be a situation where there is not a criminal conflict of interest, but there could be a question where a reasonable person with knowledge of the relevant facts would be able to question your impartiality. So an example of this was last night was a Super Bowl. And let's say that your nephew is a star quarterback on one of the teams who played in the Super Bowl. And you are a referee for the National Football League, and you are assigned to referee the Super Bowl. Well, would the crowd have any reason to question your impartiality because your nephew is a quarterback on one of the teams? Well, yeah, they would, right? And so that's what we're trying to get around here. So let's say that the review committee is considering and deliberating on a matter. The example we have here is evaluating a grant request that was submitted to the committee by a member of your household. It is your responsibility to ask yourself, could a reasonable person with knowledge of the relevant facts question your impartiality? In other words, will my participation in this damage the integrity of the review committee or sully my reputation, my reputation of integrity? If the answer is yes to either of those questions, you should contact me. We can put a recusal in place. Be happy to assist you in this matter. Again, we just want to help you navigate through these matters in a way that keeps you free from any question of a lack of integrity. When we think about misuse of position, particularly in the world of virtual meetings, I have not found a lot of situations where employees have misused position or government property, but it's important to go over. Just as a reminder, you are prohibited from using or permitting someone else to use your official title for your own private gain, for yourself, for your friends, your relatives, or anyone with whom you are affiliated in a non-governmental capacity. You also may not use it to endorse any product, service, or enterprise. And so, for example, let's say that the local library is getting ready to celebrate its centennial year in existence of serving the community. And they want you to write a blurb for their brochure that's going to go out about the centennial celebrations and all the activities. And they want you to use your title as a special government employee. You can write the blurb, but you can't use your title. And that implies, by using your title, you're implying that the government endorses or sanctions the library's activities, and that is prohibited. You also cannot use your title or your position to coerce or induce another person to provide any benefit to yourself or to another person. And again, you cannot use it in a manner that could reasonably construe to imply that the Department of the Interior, the National Park Service, or the government as a whole sanctions or endorses your personal activities or those of another. Also, under misuse of position, you also may not disclose non-public information. Non-public information is information you obtain through your service on the NAGPRA Review Committee as a special government employee, and that you know or reasonably should know has not been released to the public. So you may not engage in a financial transaction using non-public information. You may not allow the improper use of non-public information to further your own private interests or those of another. So if you obtain non-public information, you should keep it to yourself until you're aware that it has been released. You also may not use government property for unauthorized uses. Certainly in the virtual world, I don't think that's an issue. Also, as a reminder, you are prohibited from serving as an expert witness in a proceeding before a United States court or agency in which the U.S. is a party or has a direct and substantial interest. However, you can appear as an expert witness on behalf of the United States. So, for example, we had a superintendent of a national park recently who received a letter from a law firm asking him to serve as an expert witness. And I asked him if the United States was a party to the matter. He did not know, but he called the law firm and found out that yes, the United States was a party in this case. As a result, he was, and he would not be appearing on behalf of the United States. He was prohibited from serving as an expert witness. If you are asked to serve as an expert witness, the same refrain applies, contact me, and we'll help you sort through that. As a reminder, you can receive compensation for teaching, speaking, and writing if the subject matter is within your discipline or inherent area of expertise based on your educational background or experience. However, you are prohibited from receiving compensation if the subject matter relates to your official duties. And when I say it relates to your official duties, it means that it's undertaken as part of your official government duty. The chairman asks you to go speak at a conference on behalf of the review committee. And after you are done speaking, they offer you an honorarium of $50. You may not accept it. Or if the invitation to engage in teaching, speaking, or writing was extended to you because of your position in the government, the invitation was extended by a person who has interest that could be substantially affected by the performance of your duties, or if the ideas in the teaching, speaking, and writing draw substantially on ideas or official data that are confidential and not publicly available. So to really give an illustration of this, the best example I have comes from the situation of a regular federal employee. We have many park rangers who are subject matter areas and various experts areas of history. And for example, recently I was advising a park ranger who works at one of the parks that is preserving our history related to the American Revolution. And he is an expert on all things George Washington. And he has been writing a book about George Washington for which he will receive compensation. This was, the book was not assigned to him as an official activity of his official duties. The book is not talking about park programs and operations, and it is not sharing non-public information. Instead, the book is based on the park ranger's inherent area of discipline and education. And the book is perfectly acceptable to write and to receive compensation for in that case. As a reminder, many of you are engaged in fundraising activities. You can certainly do so in your personal capacity. However, you may not personally solicit any person or entity when you know that their interest could be substantially affected by the performance of your duties on the review committee. So when I say personally solicit, that means to actually single out that person either in writing or in person to ask for a donation. You may serve on the fundraising committee of a local nonprofit organization. And as the chair of the fundraising committee, you're asked to sign a letter that's going to go out to 500 people. And in those 500 people may be some individuals who have business before the NAGPRA review committee. You've not personally solicited. Personally soliciting again is singling out that person for a separate communication from you to them or reaching out to them in person. If you have any questions about charitable fundraising, again, check with me and I'll help you get through that. I'm going to touch briefly on political activity. 2022 is a midterm election year, and so we want to remind you that while you are on government duty, you may not engage in partisan political activity. So in this particular instance, the chairman has called a meeting of the review committee. You are on government duty. when this meeting is over, not just my portion, but when the whole meeting is over today, you will not be on government duty. But while you are on government duty during the time when the chairman has called the meeting, you are prohibited from engaging in partisan political activity. Political activity, defined by the Hatch Act, is any activity that is directed toward the success or failure of a political party, a candidate for partisan political office, or a partisan political group. So what does that look like? Well, if one of you had come to the meeting today and you had behind you a poster of your favorite candidate displaying his or her photograph or a vote for whoever behind you, that could be partisan political activity. Displaying, wearing a button of your favorite candidate while you're at the review committee meeting would be prohibited partisan political activity. However, so would be making online donations to a partisan political candidate or political group while you are on government duty, and also engaging in partisan emailing, blogging, tweeting, or posting to social media. So you might be in the meeting and you happen to check your phone and somebody has sent you a hilarious email that is partisan political in nature, and the temptation is just to shoot it off to your friends as fast as you can, right? Because it's so funny and kind of lightens the moment for you. Well, don't do it. You're on government duty. Wait until the meeting is over, and then you can forward that email or make that online donation. There's a lot of things that feel like political activity, but are not. So for example, issues and legislation are not political activity. So my example is gun control legislation. It feels like partisan political activity because the two primary political parties in the United States have established some territory on gun control legislation. But talking about the legislation is not partisan political activity. It becomes partisan political activity when the discussion moves from a discussion about the legislation to saying, that's why I'm always going to vote for the candidate from party X. Now you've moved into partisan political activity. And you should stop that conversation and step away from it. Again, this is while you are on duty. So some issues can be very closely related. So just exercise caution. Be sensitive to when the conversation goes from a discussion about issues and ballot initiatives and legislation to discussing the merits of a partisan political party or candidate. Also, as a reminder, in your official capacity, you are prohibited from directly or indirectly encouraging any person or organization to lobby members of Congress or elected officials of any government. Again, this is in your official capacity as a special government employee. However, in your personal capacity, of course, you have a voice. Pardon me. You may express your personal views, but not the views of the committee as a whole or the opinions of the department to anyone. So you can express your personal views to anyone. You can, of course, call your elected officials, federal, local, state. They might even know that you're on the NAGPRA review committee. They may have nominated you. You just need to make it clear that you are calling to express your own point of view and not the point of view of the Department of the Interior, the National Park Service, or the review committee. If you have any questions about this, of course, give me a call. Happy to assist you in that. As a reminder, the Foreign Gifts and Emoluments Clause in the Constitution prohibits you from being employed by a foreign government. We see this frequently in special government employees and regular federal employees who often serve as professors at foreign universities. It's unusual for us in America, but oftentimes universities in foreign countries are political subdivisions of the federal government of that country. So if you are offered employment and it has foreign involvement, give me a call. We will work with you and with attorneys in the Office of the Solicitor to ensure that there is no violation of the Emoluments Clause. There's also restrictions on accepting gifts from foreign governments. If you are offered one, let me know and I'll help you work through that. And if you have any questions about any foreign employment or gifts, again, just give me a call, contact us, the ethics office, and that is it. I am done sharing my screen and you have received your annual ethics training. Melanie has my contact information if you have any questions or need to follow up. As many of you have also heard from me throughout the year with regard to financial disclosure, and you have my information should you need anything. I'm happy to assist in any way that I can. And Melanie, I'll turn it back over to you.
Great. Thank you so much, Margaret.
You're welcome.
Again, I appreciate the time of the review committee to take during this public meeting for your annual ethics training. I also think that it is important for the general public who attend these meetings to be aware of what those ethics responsibilities are, both as participants in these meetings, but also perhaps as future review committee members themselves, to be aware of these responsibilities that all federal employees, including the review committee, have. Mr. Chair, would you like to move forward in the agenda?
Yes, I'd like to. I also want to extend my thanks to Margaret for that training. I also sort of additionally hope that the non-governmental attendees who may not have had the benefit of that kind of training in other contexts found it enlightening and maybe even useful. And Madam Chair, would you, you may be intending to do this already, but we want to review the rest of the meeting agenda as well. Any additions or things for that, but yes, let's proceed.
Okay, yes, I have that next on my list of things to discuss. I will say that the next item on the agenda is public comment. So I would encourage anyone who might wish to make a public comment to raise your hand or to put your name in the chat. And I will allow you to turn on your microphone and participate in a public comment. While we're waiting for people to raise their hands or to let me know that they're interested in public comment, I will say that we did recently update the agenda as well as the meeting materials for this meeting and for future meetings. Again, you can find both of those on the NAGPRA program events page. And I will once again put that in the chat. There's an updated agenda as well as some additional meeting materials that we posted. We did not receive any requests for presentations or dispositions at today's meeting. However, I did receive 2 requests for dispositions for future meetings and have added those to the agenda. We've also added the related meeting materials to the meeting materials files. If anyone would like to make a presentation to the review committee or would like to submit a disposition request, you can contact me directly at nagpra_info@nps.gov. In addition, in the meeting materials, the review committee provided me with a compilation of comments on the draft regulations, and that was put in the meeting materials as well. I believe that was posted on Friday afternoon, so I wanted to be sure the committee as well as members of the public were aware that there is that additional material available. And in addition to that, we also received a tribal comment on the draft regulations intended for the review committee's review. So I've provided that to you as well in the meeting materials. I actually just heard from someone else who submitted a letter that I'll be posting to the meeting materials. So please continue to check those meeting materials as we will update them as things are sent to us.
Madam Chair, I might add that the written material, the letter and the copy of their comments is from the Confederated Tribes of the Colville Reservation. And reading through that, it seemed to me there were some similarity between at least some of the comments that the review committee has now assembled in the working document that we're going to use in the next section of this meeting. So I appreciate the tribe having shared that and was glad to have an opportunity to review it. And I'd recommend others look at that as well.
At this time, I don't see anyone who has raised their hand or requested to make a public comment. Again, if you're interested in making public comments, you can raise your hand using the hand raise feature of the meeting, or you can type your name into the chat. Again, Mr. Chair, we did not have any other requests for presentations or disposition requests at this meeting. We could return later to public comment if someone did raise their hand or put their name in the chat. But at this time, I do not see anyone requesting to make public comment.
Okay, thank you, Madam Chair, for that session and for the information in it. Should we proceed to the next section?
Certainly. We could move on to the next item in the agenda, which is time for the review committee to discuss revisions to the regulations. If I might, I would like to provide just a little bit of background for the committee as well as those in attendance on this topic.
Yes, that's fine. I've got some of that as well. So why don't you?
Well, would you rather?
No, you can go ahead first.
Okay. Just as a reminder for everyone, as of in July 2021, the department publicly provided a draft of proposed revisions to the NAGPRA regulations. This draft was specifically provided to facilitate tribal consultation prior to any proposed changes to the regulations. As I think many of you are aware, under federal government policy, as well as executive orders on tribal consultation, the department was specifically seeking input from Indian tribes and Native Hawaiian organizations before it took any action on revisions to the regulations. The draft was provided publicly to be a discussion document for tribal consultation. The department also requested at that time that the review committee develop written recommendations on these NAGPRA regulations and any changes to it. By the end of September, the department had received 71 letters from Indian tribes and Native Hawaiian organizations, as well as from several tribal organizations that provided specific input on the draft text. As I mentioned at your last meeting, in December of 2021, the department informed Indian tribes and Native Hawaiian organizations that a proposed rule would be published in early 2022 and would incorporate, to the maximum extent possible, the input from tribal consultation. At this time, the review committee is continuing to develop written recommendations on revisions to the regulations. At your last meeting on January 31st, the review committee agreed to a process for developing written comments, as well as agreed to solicit input during public comment and presentations to help inform the review committee's recommendations. It's my understanding that one member of the committee has reached out directly to scientific and museum organizations to solicit that input. For everyone's information, I want to be very clear that this is only the beginning of the regulatory process. The department will directly solicit public input after publication of the proposed rule in the Federal Register. The department is also planning on conducting additional consultation with Indian tribes and Native Hawaiian organizations after publication of a proposed rule. In addition to the proposed regulation, the department plans to provide direct written responses to the input that it received during tribal consultation. So I just wanted to be clear that we are still in the beginning phase of this process. While tribal consultation has occurred, the next step is to solicit public input. As a part of the regulatory process, the department will respond directly to all comments that are received during public comment period prior to publishing any kind of final rule. So I just wanted to clarify for the committee, but more so for the folks in attendance, of what the regulatory process is. So with that, I can turn it over to you, Mr. Chair, to lead the discussion of the proposed regulations.
Thank you, Madam DFO. I do have a few introductory comments if my fellow members will put up with that. And I have a couple questions actually for you, Madam DFO, based upon your comment just now. As you noted, at the last meeting, January 31st, we discussed, the committee discussed how it would deal with developing a set of recommendations for the secretary for this revision to the NAGPRA regulations. Although we asked for one, the department hasn't been willing to provide a updated copy or a copy of an updated revision that, if it exists, would reflect changes that the department might have made to a draft based upon the tribal consultation. I suspect in our discussion today, we would repeat that request so that we wouldn't be working with a July 2021 version for our comments. We'd have the most up-to-date version. So that I think is an issue. You mentioned also that when that July 2021 draft appeared, that the committee had been asked for recommendations, and I don't recall exactly. We discussed that, but I don't recall that we had received any kind of a formal message from the secretary or one of the other assistant secretaries working on this to that effect, although I'd be glad to know that we had been formally asked for it if that is the case. So in any case, the committee has agreed at the 31 January meeting that we would go ahead. We would use the July draft, since that was the only thing we had, to organize our comments and to work on specific recommendations for the secretary. So we will do that, and we'll get started with that today. The committee at that January meeting decided that the best approach would be for individual members to prepare written comments or questions about the draft that we have in front of us, and that these would be compiled into a working document that would be used at this meeting, and I suspect at the next several meetings, to discuss the committee's, what committee recommendations might be, what the review committee's recommendations might be. So I thank my fellow members for the extra time that they've spent in the last couple of weeks to assemble those comments, and special thanks to Tim McEwen for actually doing the compilation, which is now available publicly so people can follow along or provide us with their comments on the points that we're going to be looking at and talking about. And we use this approach to try to develop a written set of recommendations, which the committee as a group can submit to the secretary for her consideration and for the department's consideration in moving forward. Madam DFO, you've already shared the where other listeners or organizations that have concern about what happens next with the regulations. So I would encourage also those of you at this meeting who are attending, listening in, to take advantage of that and send to the National NAGPRA program for passing on to the review committee your comments on this, or your recommendations, or your questions, that we might take those into account. Also, organizations or individuals who might have an interest in presenting some of their information or recommendations or questions to the committee should also follow up on the DFO's suggestion and see if we can get some of those onto the agendas for the remaining set of meetings that we have for this next couple of months. Just one other thing, Madam Chair, the regulatory process that you described, with the next step, official step, being the public publication of proposed regulations, doesn't necessarily have to be the next step, or could be the next formal step, but in between now and whenever that happens, the activities of this committee could focus on further developments to drafts for the regulations. And I do recall that, having had some involvement in the initial development of regulations, which we all agree are not perfect and could stand some streamlining, I'm sure, did involve a set of discussions that were focused on review committee meetings before an actual formal publicly accessible copy was published in the Federal Register for more general public review. So I think, in fact, there are alternatives to the maybe somewhat shortened version that you presented in your introductory comments, but we can have further discussions on that as well. So those are just a couple of intro comments that I have, and I'd welcome any statements or comments from fellow committee members about the process and how we might proceed, or concerns before we actually dive into looking at the actual document that we have, the working document that we've created for this purpose. Does anybody like to make a comment? Or John? Yes, please.
Yes, I was. Thank you. Going back to your earlier comments about the process, and not to, jump too deeply into where we are. I know there are some comments about, on the front end of where we are. But I guess, as you say, no process is perfect. But as we're working or as everyone is trying to work together on this, particularly from the tribal consultation part, would certainly agree, and I'd certainly support. But I'm wondering if that initial consultation phase, it seems like it was very abbreviated, given the title of the law, the intent of the law, the regulations that are presumably going to support this process, particularly with the one-on-one consultation with the tribal nations and tribal governments. And it just seems to me, anyway, that if we're going to place some sort of importance on the consultation from the tribes, it just seems, with the tribes and their input, it just seems that part of it, to me, seems very, very shortened. If we're really concerned in wanting to hear what the concerns of those tribal nations were. I know that the office and the agency, and we're certainly thankful for that, made some moves to extend, the time frame in which for the tribal nations to get their formal comments in. But it just, even on that part of it, it still seems very sort of abbreviated. And if there's wherever this fits into the process, it would seem to be, and it seems from other people who have submitted comments, that certainly listening to, or accommodating another second round of an opening up for more comments from the tribal nations to take part, for those comments to be considered in the draft, I guess in the review and drafting process. And with that, I mean, I certainly support the comments that have supported that it would be helpful. I think I said that in the last meeting too. It will be helpful, I think, to us to see to what extent that, at least initially, the tribes, where those initial comments, how they've impacted where the drafting process is, what changes were actually taken seriously. I mean, I think that to me that would be very telling. A comparison of the first draft that was issued last July and what changes have been made, to what extent that we're going to be listening to the tribal input. And so I certainly agree with certainly extending more formal that'd be a recommendation. I mean, more formal consultation with the tribes the tribal nations who certainly felt like that process was shortened to be able to get their formal comments and not left out of that process.
Madam Chair, I don't know if you want to respond to that. I know you're not in charge of consultation with tribes on issues like that, but you might have some additional information to share about what the intent of the department is regarding that particular idea of additional consultation with tribes.
Certainly, I see that Honor has her hand raised. But again, as I told the committee and on December 15th, and as I referenced in my introduction, the Assistant Secretary for Indian Affairs did issue a letter to Indian tribes and Native Hawaiian organizations regarding the regulations. That letter stated that revisions to the NAGPRA regulations are long overdue, that Secretary Haaland is committed to finalizing and implementing effective revisions during her tenure at the Department of the Interior. And in order to realize this goal, the department is diligently working to incorporate tribal input received during the first round of tribal consultation into a regulatory proposal that reflects tribal input to the maximum extent possible for publication in early 2022. I encourage you, the Assistant Secretary encourages tribes to participate in the next round of tribal consultation that will be held upon publication of the proposed rule. So again, in terms of your comments, John, but also Frank, on the process, the department in that letter of December 15th laid out what it sees as this process moving forward in response to requests for additional consultation, as well as requests for other forms of process to develop a proposed rule. So as of right now, that's the plan for the department.
Thank you, Madam DFO. Honor, I'm sorry I missed your hand up before I asked Melanie to comment on John's comment.
Thank you, Frank. I'm in agreement with John, and also I listed out several recommendations there on the draft that went out for the committee to follow regarding further consultations with tribes prior to the release of official public comment. I think that there were a lot of considerations that haven't been taken into account, but yet we've heard from tribal members and tribes over the past year or so about the fact that COVID had decimated many of our and affected many of our communities and stretched thin the resources located on tribes, during which point consultations were happening. I think that's something that needs to be taken into consideration. Furthermore, there need to be meaningful tribal consultations, and by executive order recently by President Biden, they're calling for robust and meaningful tribal consultations. I think that's absolutely necessary in the case of these regulations that we're considering. Furthermore, I have a lot of concerns over whether tribes have actually had the opportunity to provide comments because there have been comments made that we've heard as a committee that the tribal historic preservation offices did not get letters in time, and some tribal leadership also did not get proper notice. So I would urge the Department of the Interior to have another round of tribal consultations to ensure that this process takes place in the way that it's meant to. Thank you.
Thank you, Honor. John.
Yes, to that regard, follow up on that. And I know we keep saying this repeatedly through the meetings, and to certainly to support that. If they feel comfortable to also voice those concerns or opinions if they have, because I've certainly heard them from certain people. But this would be a good forum to hopefully those would issue or make those comments that they feel like that the initial review, the first round was certainly rushed or abbreviated. I think that might be a perfect forum for at least the review committee to hear that in this public forum. And I think that there are some comments to that in the letter that we have received already that they felt that in some ways that the process was somewhat rushed on the front end there. So I would certainly invite any of the tribal nations who happen to be listening on the call, or those who happen to know anyone who have concerns, if they certainly feel comfortable, to certainly make those comments formal or certainly make them in the public forum. Thank you.
Thank you, John. I would note actually that in the letter from the Colville Confederated Tribes at Colville, they make a point very much like that as well. Another set of consultations before the publication of proposed revised regulations in the Federal Register for general public comment. So something to yet an additional opinion there. John, your hand's still up there. Okay, thank you. Anyone else on the committee want to start out with a comment? Tim, go ahead.
I think this would be, obviously, I think that it's important that we hear from the tribal perspective on the draft proposed rule. I do remember that at the February 2nd hearing before the Senate Committee on Indian Affairs, the Associate Director from the National Park Service told the committee that they were in the process of preparing an item-by-item response to each of the issues raised by the tribes in their commentary. And I think she may have thrown out a number of how many individual issues there were. I don't recall what it is. But what the status of that document is, Melanie?
The Assistant Director for Cultural Resources, Partnerships and Science, Joy Beasley, at that February 2nd hearing did refer to the same comment that I provided in the opening, that the department is working on direct responses to tribal input that will respond directly to each of those comments that were received during tribal consultation, and that will be published with the proposed rule.
Thank you.
If I might follow up on that.
Yes.
So
ahead,
this in effect would be like a preamble that would respond to previous comments.
It is a document that would respond directly to input from Indian tribes and Native Hawaiian organizations.
Thanks.
Thank you. Okay, so if there aren't any other more general comments at the start, why don't we turn our attention to the working document that we have and just work through it. I think comment by comment. I think that was the idea. So what I propose is that we do that until about 2:30, And at 2:30, we take a break. That'll be halfway through the meeting. And then we come back and finish off the meeting, continuing to go through the working document. And I don't believe then, Madam DFO, there's anything that we need to do in the rest of the meeting. If there's a new business, old business section, I guess we could leave 5 minutes for identifying new business. But mostly we can spend most of the rest of the meeting on reviewing the working document. Is that your sense?
Yes, the only other item on the agenda is old business or new business. We did not receive any requests for public comment a few minutes ago. If the committee would like to provide that opportunity again at the end of the meeting, we could also do that as well.
Okay, thank you. Then if you turn to the February 11th document, the working document with comments from review committee members that Tim's compiled into a single document, there are actually about 3 pages at the beginning that are general comments, some of which I wrote and some of which Honor wrote. And then we get into a more section by section assessment. If I could just summarize the comments that I made, the general ones, and then give Honor a chance to do that with hers. And then we'll go through them one by one after that. The 3 general comments that I made, one of them we've actually talked a little bit about already, which is the first one, that that the committee is attempting to work in, I would say, a less than perfect kind of framework of not knowing exactly what the department is planning in terms of revisions. So we're dealing with an earlier version than an earlier draft than what we suspect would appear in the Federal Register if that's the next step that the department plans to take. Again, I think the committee's on record of requesting a more up-to-date version, and we might want to continue that, or at least talk about it a bit if people want to do any more talking about that. The second general concern really is, I guess, a bit more of a specific concern, but I raised it here because I think it's important to the changes that seem to be proposed, having to do with a geographical affiliation term that might be used as a not more than a supplement to, but a substitute for cultural affiliated, the cultural affiliated or cultural affiliation term. Actually, I put it in as a general concern because I wanted to highlight it, but we could actually also talk about it in more detail when we get to that part of the specific specific items that we're going to be looking at through the course of the document. So I'd be willing to set my comments aside and really raise them again when we get to that part of the draft regulations. Final general comment, the third general comment, is that my reading, at least, of much of the document, and many of the revisions, not all of them, but many of them, is that they actually require additional work, and not work that's unnecessary, but additional work, both by the tribes as well as by the museum and scientific organizations, or at least those that hold collections that are covered by NAGPRA, and by the federal agencies. And it just occurred to me as I was considering this concern that the committee, in a number of its more recent annual reports to Congress, has pointed out the additional resource need that tribes have, and that the other kinds of organizations that are involved with meeting the NAGPRA objectives have consistently pointed out that there are additional resources of staffing and for other functions that are required by complying with the existing regulations that haven't been available and that aren't available, and that's stretched the process out in many instances, in many situations, longer than maybe anybody really wants it to be stretched out. and certainly is responsible, at least to some extent, for the backlog that exists, that people are diligently trying to work through. And I just wanted the committee members to keep in mind that particular sort of overriding issue as we go through and look at the different changes that are being proposed in the revisions. And maybe always ask the question, well, you know, is this change something that's feasible without additional funding? And if it's not, how can we in our recommendations emphasize the need for certain kinds of additional funding for staffing or for, again, other kinds of activities as well. So, so that's the nature of the three general comments that I wanted to make and get at least get into our minds as we work through the more specific changes, and where those three kinds of concerns apply, maybe fold them into our recommendations on the more specific section. So unless anybody wanted to comment on those general things, I would turn over the opportunity to comment to Honor to do maybe a similar kind of a summary and highlighting of the comments, many of the comments that she made at the beginning of the document as well. Honor, is that okay?
Yes, thanks, Frank. I had very specific comments, general comments about the draft regulations. And again, in line with reiterating the need for adequate, robust, and meaningful tribal consultations, I brought up within one of my comments, or several of my comments, the issue of notice, and that tribes had expressed their tribal leadership or TIPO repatriation offices did not necessarily receive adequate notice. I did make some recommendations pertaining to that. The first being that the National NAGPRA program should develop a listserv or other form of notification to ensure all tribes and NHOs and their TIPO repatriation departments are updated on upcoming meetings of the review committee, notices, events, new policies and procedures, and the NAGPRA draft regulation process. And that they also have the opportunity to participate in all meetings of the National NAGPRA Review Committee. I think that this has been developed in other agencies. I understand that there was some concern about the changes that occur in tribal leadership or in certain repatriation or TIPO offices. However, I do believe that this is part of the government to government relationship that the federal government has with tribes. And if this is a concern about things going, you know, out of date, then I'm sure someone can devote every 6 months to calling the tribes and making sure that the information is up to date. I also mentioned regarding the draft of the NAGPRA regulations, and I said this earlier, that there should be another round of tribal consultations before it's opened up for public comment, and that these take place directly with tribal governments and NHOs and involve more than a mere letter. So I'll start with that one, and I have several others that I'd like to bring up, but I wonder, Frank, if because we have so many of these general comments, if we could go through them maybe one by one and be able to discuss that with the committee.
Yes, Honor, why don't you go ahead and do that?
In the another comment that I had made also was that the Department of the Interior and National NAGPRA program should also provide opportunities for spiritual and ceremonial leaders to comment on the draft NAGPRA regulations. These viewpoints are incorporated in throughout the law, and also traditional Native American religious leaders have also been an integral part of drafting NAGPRA, and of course its establishment as federal law. So just given those two, and I have more comments, Frank, that I think gets into definitions, of course, and is sort of release for public comment and how we should proceed through this. But I'd like to start with that for comment by the rest of the review committee.
Okay.
Thank you.
Are there others who want to comment specifically on those two proposed recommendations from Honor? Well, let's see, I mean, one of the ways we can do this is if those two seem reasonable, we come back around to them, maybe in a second draft through a second review of the document as we're looking at what specific recommendations the committee as a group wants to make to those. So those are highlighted. The idea of National NAGPRA developing more direct communication links to tribal programs that are set up to deal with this, or with traditional religious leaders and other traditional groups within tribes. And then the other would be the idea of ensuring that tribal religious leaders have the opportunity to comment on the regulations. Did you, Honor, did you mean that in terms of prior to public comment, or as part of the consultation process that the department might undertake?
Well, my current recommendation, and I'd like to hear also what tribes who may be on the line, or tribal members, or other folks on the line might have to say, but my recommendation is that this next round of tribal consultations occur before things are opened up for public comment.
Okay, right. Yeah, all right. Okay, well, so we could consider those to be two recommendations that the committee wants to, as what I'm thinking is, if we go through the working document and discuss the specifics that we've got there, that we highlight the items that the committee wants to make a specific recommendation on, or we get questions answered to our satisfaction by Melanie or our legal colleagues from the department, and it doesn't become an issue anymore in our minds, so we don't have to develop a specific recommendation about it. So if that seems sensible to everyone, we could highlight the two that Honor mentioned. We might, in a way, at least come back to at least two out of the three of the general comments I had in terms of whether we want a specific recommendation to the secretary related to the funding issue and related to the process concerns that we've expressed in recent discussions ourselves. If that's the case, then we can move on and start discussions of the more specific sections, which I think we begin. Well, Tim, you actually had a general comment as well, which you actually already raised, I think, in terms of the preamble. What's the preamble going to look like, and would we be able to have an opportunity to review that? But maybe you want to say some more about that. That's at the very end of the general section before we get to talking about subpart A.
I think John had his hand up.
Oh, I'm sorry, John. I keep missing people's hands up. I apologize for that. John, go ahead, please.
I'm willing to hold off if Dr. McEwen would like to make his comments, if we want to go on that, or if he was already in the queue.
So, Tim, you want to go ahead, or you guys?
Well, thanks, John. I did, one of the general comments that I put in basically was the review committee has requested certain information about the development of the regs this draft and the comments from the tribes on it, which we have not been provided. And I think that not providing the committee with the results of the tribal consultation certainly represents an obstacle to us fulfilling our responsibility to consult with the secretary in the development of the regulations. And I would suggest that we remember this when we prepare our report to Congress for FY22.
Okay. Okay, thank you. Thanks, Tim. I just feel that compelled it also to add it at this point in terms of general comments that we haven't at all had general comments from museum, scientific organizations, or federal agencies about what the July version of the revisions would mean in terms of their own operations. This gets back in part to cost and ability to actually carry out changes if some changes were to occur. And I think I would think we would want to also get those points of view as we develop the regulations. We hopefully will have time to do that and have opportunities to do that in the next, I guess, next 4 meetings that we have already scheduled. So that's just maybe another thing to keep in the back of our minds also. So thanks, Tim. John.
Yes, thank you. And since we're in the general comments section, and I had made note that that I'd submitted for at least for this part of the working document. I guess one of my general comments, and maybe what I'm getting ready to say seems obvious, but so I go back as we start moving forward. It's something that I've thought about. I've been thinking about as reviewing the draft, both the current regulations and the draft that's before us. And so I go back to think, so what was the intent of this law that was, as it was initially passed? What was the intent of this law? And how does it sit, or how does it exist as sort of a human rights sort of legislation? Because it is focused, let's be honest, it is by the very nature of its name, that the title of it sounds like it does have a purpose. The purpose of this law seems to be built into its legislative, its name. And so thinking about that moving forward, I know we're working on the draft, looking at the new draft before us. So what was the intent of the law, and what are the regulations supposed to do? Because when you look at the law and start thinking about the regulations, the intent seemed to be, at least in that initial act, that Congress had in mind certain deadlines, certain benchmarks to be met for the return of human remains, or the identification of them in these federal collections or museum collections. And I know we've talked about it before, but it did have in mind, we seem to think we've even made the comment in our reports to Congress that time frame, there was much more, it was much more complex than originally thought. But that being said, I think it seems the intent was to acknowledge these tribal communities and the importance of, I don't want to say a redress, but it was acknowledging some of these, when you say these offenses, if you will, about the holding of these certain collections. And it seemed to be, even as the regulations they exist, was how do we move from point A to point B to have the ancestors and the cultural items and cultural materials returned to these communities. So that's something that certainly that at least weighed on me, and I think that's probably weighed on perhaps those who are reviewing the draft. So in thinking about that, what does this do, and what is this? To me, it's supposed to advance this forward movement of the return of the ancestors and the cultural materials back to these communities. So I've been thinking about that, and I'll certainly make comments as we move forward in the sort of the more as we dig deeper into the regulations. But I had, with particular note to the letter that we did receive, and it was something that I had thought too, is that it reads almost overly complicated. And I think that we're trying to make the process, one, for tribes, and two, the agencies, to make this a less complicated and more efficient process. If I'm misunderstanding this in some way, please let me know. But that being said, I think this is, to me, it's really strange to be talking about this when, to me, it's about this as it exists as a human rights sort of this idea of this law, which is acknowledging that these wrongs were perpetrated upon the native nations, and to make at least the majority of that right. I mean, that's what, I've read into some of the past comments on this as we delve deeper and sort of weigh the balance of the interests of the tribal nations with the comments that we'll receive from the scientific community. But that being said, I go back and review the initial act, and it really places a priority on and with and for the native communities. The reason why this was passed and what it's meant to accomplish. And if like I said, if it did have those goals that were sort of understood or built into it, then to me, as we work on and make our comments, and we certainly all have our opinions, and it's going to be interesting as we walk through this, but what the intent of the law was and how the regulations are going to ultimately support that. And it sounds like, at least from the comments that we're receiving from the secretary, the office of the secretary, that an importance it seems like there's a thought that's been revisited on the initial passage of the law, and it's and the importance it's placing on the return of these of the human remains and still what's out there to the descendant tribal nations and tribal communities.
Thanks, John. Yeah, I mean, clearly, the repatriation of Native American remains, human remains, and other types of cultural items covered by the statute is the intent of the law. I think that I think a lot of the issues that come up now are where the cultural affiliation, as it's currently envisioned in the statute, isn't clearly attained or clearly agreed upon by the different parties, and I think in part it's that the actual resources don't exist, and the financial resources or the staff resources or things like that to try to solve that particular problem, and in some cases just to solve the getting in touch problem and doing sort of full and complete consultations between the museums or the agencies that hold the actual cultural items and human remains and the tribes that to which those remains may be culturally affiliated. So I think that in part we're at that point in the actual implementation of the law as to what I think maybe the original authors of the act saw would happen eventually, but didn't provide a clear path forward or an easy path forward, and that in part that might be because there's not an easy path forward. It takes a lot of time and it takes time to get to agreement or consensus or just recognition of an affiliation. So it's if it were easy, we wouldn't be spending all this time working on it, trying to make it easier. So I think we should, as we move forward, we should look to that as well. How can we improve the situation as opposed to just not improving it or making it somehow more complicated, as you point out. We actually are just after 2:30. We've sort of just gotten warmed up, so I hate to actually call for a break, but it's probably useful for us to keep going with a short break. Madam DFO, do we take a 10-minute break at this point and then come back and go through the rest of the meeting with in one swoop?
Certainly, I'll set a timer for a 10-minute break.
Okay. Okay, 10 minutes, everybody, and we'll get back to going through the specific sections. Thanks very much.
Thank you.
Madam Chair, we're back. And you're muted.
How about now?
Yeah,
Okay, thank you.
back on, back on.
Okay, I think we're ready to go.
Okay, then let's turn to the bottom of page 4 of the working document. Oh, and I am sorry to say that the first comment is mine. Trying to get off the lectern here. So, I have a concern that the current purpose of the act and the regulations actually has been dropped. I don't necessarily object to the new text that is being proposed, but I would say that the first part that might just be added to what's already there. The first part of the purpose currently reads that the regulations are to identify what is needed for a systematic process for determining the rights of lineal descendants in Indian tribes and Native Hawaiian organizations to certain Native American human remains, funerary objects, sacred objects, or objects of cultural patrimony with which they are affiliated. If some of the other parts of the proposed revision are incorporated, in particular, some kind of an addition of geographical affiliation, that process, the process of determining the rights or which tribes and other lineal descendants or Native Hawaiian organizations actually have the right for repatriation and disposition is going to need to be gone through also. So that is still an important part of what the implementation of the law means, as is how dispositions and repatriations are carried out. So I would argue that we retain, rather than eliminate the existing purpose section, that remain in place, and the additional text about the procedures for disposition and repatriation simply be added to it to make maybe a more complete description of what the function of the regulations is. Other committee members have opinions on that?
Can I just ask a clarification there, Frank? Are you saying that the part of the existing text that you want to preserve is the with which they are affiliated? Is that the part you feel has been lost?
Well, the fact that there's a process and that needs to be gone through by at least by the agencies, well, by all of the involved parties in a particular situation is lost if you don't talk about how there needs to be a determination of that prior to either disposition or repatriation, I guess, is the point I'm trying to make.
So that there's a process for determining affiliation is the part, the affiliation part that's missing in the draft text?
Yes, that's part of it. There's also the consultation part of it. I mean, it's, obviously it's not that any of these entities work in a vacuum, the whole idea is for all of these entities, the organizations that currently hold these kinds of remains, talk to, consult with, learn from the organizations or lineal descendants to whom they rightly belong, is an important part of the process and procedure. So I think that is lost. That is maybe just encapsulated in 2 words. If you lose the current text, it's encapsulated in the words disposition and repatriation, which I think is not enough of a recognition of the front end on disposition and repatriation that is gone through by all parties and is part of the regulations in terms of what's required.
Okay, I guess I'm confused because I don't see that in the existing text. It just talks about the process for determining affiliation. And the revision says a process for disposition and repatriation. I think it kind of goes to what John was saying earlier about the purpose of the act. And I think a conversation here about the purpose would be very beneficial to the committee as well as to the public. So.
Well, I'm not suggesting this as a disagreement with what John has suggested. I'm simply saying that there are a number of different activities that are required as part of the process, part of the procedures. And there's a front end on this that is the inventory effort and the summary effort, which are still part of the process, even in the revised, what's proposed as revised, and that those involve examining records and compiling information from existing records and drawing inferences from those kinds of things, as well as talking to organizations and individuals that have traditional knowledge or that have knowledge that may not be on hand at the agencies or the museums that need to make some of these initial decisions and then move forward with them. So I think we need to recognize that that's an important part of the procedures, which I think the current text in the purpose section does. And we
Can you clarify for me, is it both the revision and the existing text talk about a systematic process? The difference between the two really is about affiliation, the end point, I would say. So, the existing text says the regulations develop a systematic process for determining affiliation, if you take out the middle part. The revision says the regulations provide a systematic process for disposition and repatriation. And I think those are fundamentally different statements. The purpose is disposition and repatriation versus a purpose for affiliation. And I think it would be worth kind of discussing that.
Well, I disagree with that, but let's see what John has to say. Go ahead, John.
Yes, and so that goes back to my earlier comment about us getting, the regulations getting everyone from point A to point B. And so when I look at and maybe others might feel differently, but when I look at the current regulations, I mean, there's a statement in there about this is a process that determining the rights of lineal descendants. I think that's kind of a heavy statement to, is this really to determine the rights of these descendant communities, or is it moving this process forward? That's kind of I don't know if that's a bold statement to take, but I mean to sort of step in and say to determine the rights of who's determining those rights of the descendant communities, and so that's a concern, or how that sort of weighs in, because that says someone else has or at least it has the connotation to say that someone else has is somewhere in the process of determining the rights of these descendant communities.
Maybe I get that, John. I see that maybe a problem with the word determining, and maybe it's more recognizing. The rights exist. I quite agree with you. The rights exist. It's a matter of ensuring their recommendation, maybe, or their ensuring their recognition. And there's a process that is that people go through now to do that. And I guess Melanie would be maybe relying upon the term a systematic process, but it doesn't, I guess it doesn't give me a sense of the substantial amount of work that has been required to identify those and identify where those rights exist, and looking at what information does exist, a preponderance of the information can, it takes time and it takes focus, and it's an important part of the process. And it just seemed to me in comparing the two statements, and that maybe individually, neither of them sort of gives you the full idea of what is going on. So by retaining what's there already and fitting the disposition and repatriation process as part of that, it seemed to me gives a fuller sense of what the purpose of the regulations are.
Like I said, I'll then I guess I go back to is that and I don't, I guess at least at this point we can obviously we'll further discuss this, but I don't think right now anyway that a shorter statement in any way diminishes the process of the work that's going to make these determinations, because I think that that's further fleshed out in as we make our way through the regulations. I just, it's kind of like the guide, I don't say the guiding principle, but why, the purpose. So why are these regulations existing? And again, I go back, it's supposed to get everyone from point A to point B. And so then I think anyway that our recommendation will look as it will, but I think that some of those things are further covered as you make your way. I even think some of those questions come up in the definition part. I think we'll have a further discussion on that as we make our way to the definitions on those. But I tend to right now anyway, the thought is that the shorter purpose statement, and I really, I do have the great concern about the process for determining that statement, or even acknowledging who has that authority, or who has that right to sitting in a certain position. So when it says it's a process, and so for the process for determining that, on the other side of that, it's a process for who those sitting in those government agencies or these museums to determine the rights. I said, so I go back to that, those rights of those lineal descendants or these tribal nations are already there. And so and those have already, to me, on that part, those have already, whether just from the people aspect of that, as Native Americans or American Indians of these tribal nations as people, or as they exist as sovereign tribal nations, that's already been addressed in other, that's already been addressed in other public forums, as how the federal government, has that relationship where it's set in this, but I'm not sure that it's up to some of these agencies to determine those rights. And I think that could be a really sticking point for tribal nations, or just someone in general. I'll flip that back, to sort of flip it back to say, would any of us like someone, who are you to determine what my rights might be in a situation like this, or how one might feel especially if you're on the receiving end of that.
Yeah, I know, Shelby, if I could just quickly say a couple of things, and then we'll ask you for your comments as well. And I get that. I do get that. I understand that, John. That's why I think determining is not a good verb there. Recognizing might be better. And I think all parties, again, have a responsibility. I actually think the initial responsibility, or a substantial responsibility, upon the museums and the agencies that hold the remains, is maybe something that we want to build into that first part. I'm simply saying that that part of the process, which everybody contributes to, and again, I'd certainly be willing to work with some of the wording there. I just think it's important for us to recognize, and for future users of the regulations, when we do the revisions, whatever revisions there are, to see that as part of the function that leads to disposition and or repatriation. I'm not disagreeing with you on your basic point about the rights matter, for sure. Shelby, go ahead. You're still muted.
There we go.
There you go. Thank you.
Thank you, Frank, Mr. Chair. So I just have some real concerns with the purpose as it's stated in the new new draft regulations, because there is no reference to the act. And what I think, just what John was talking about earlier, and the purpose of the act is, bottom line, is repatriation, and not having the act in the purpose. I think, as we have in the regs, right, in the current regulations, my concern is, as some of us have been working in this for 30 years since the implementation of NAGPRA, with this next generation coming along, and they're coming into museums and federal agencies. I think they need to be aware of the act, and they need to be familiar with the act in order to work with the regulations, however the new regulations are going to be. And I think it's really important that the act be referred to in the purpose like it is in the current regulations. And I just feel that with new people coming into this work, if they're not familiar with kind of what are these regulations for, they're really to carry out the provisions of the act. And I think that should be put back into this introduction as well. Thank you.
Thanks, Sheldon. Thank you. Other committee member comments? Well, perhaps in this case, if I were to go back, say, and try to formulate this as more of a recommendation that change the language more along the lines that John suggests and Shelby suggests, and then bring it back to the committee to see if can be some agreement on a recommendation. Would people be willing to go forward with that idea? Yes. Sort of head nodding. Any? Okay. All right. Okay.
One thing,
thank you for
Frank,
that.
One thing that
Yes.
I might recommend when you do that is just go back and sort of following up on what Shelby said, to go back and look at the act and see what we've got there, and also look at the House report on HR 5237, because that was Congress's intent. So I think we need to ground ourselves in the statute and the legislative intent.
Okay, that's good idea. I'll do that, Tim. Okay, thank you all. So the next.
Frank, this is Honor.
Oh, yes, Honor, go ahead.
Thank you, Mr. Chair. I actually don't mean to interrupt the flow of this, but I was not totally prepared to move into this section before we finished up some of the comments above it.
Oh, I'm sorry. I thought I apologize. I didn't mean to not do that, but I thought you had said before we took the break that you had identified at least the first two concerns, and we continue to look at those, but you might bring the other ones up as we went through specific sections, but
Yeah.
I apologize. Go ahead.
No, that's okay. I had also wanted to bring up some general concerns here, and I'll run through them quickly that I think are important for the review committee as it goes through this process, and just comment about some of the things we just discussed that were brought up by you, John and Shelby. I really think these are also sections that, of course, we want to hear public comment on, and we want to hear from the tribes on, as we go through section by section. And my recommendation also is that we ensure that throughout this process that we don't kind of close down one section for public comment, and to leave that opportunity open as well. Okay, so just heading back up to page, let's see, 4 above, up at the top. I also wanted to mention that there has been great concern over whether investigations for failure to comply are occurring in a timely manner, and whether prosecutions for these NAGPRA violations are proceeding forward. Information pertaining to civil penalties, investigations, and prosecutions, including any backlogs, should be submitted to the NAGPRA Review Committee so that we will be informed of successes or failures in the current regulations and how they may be revised. I think this is imperative. We are provided with this information so that we will be able to fulfill these obligations to provide recommendations to the Secretary of the Interior on the regulations. I had written here, because this is my feeling, that the NAGPRA Review Committee does not condone a hierarchy of enforcement in federal laws that unjustly places laws that pertain to tribes and Native Hawaiian organizations at the bottom of enforcement interests. And that comment, comes from repeated attempts to try to get this information. And I think there are concerns out there, certainly among the tribes and others, about where their complaints have gone at this point. And I just think this is a very important thing that we need information on to also further consider the regulations and what this procedure is that's being set up through the regulations currently. And going back a little bit to what John was saying, but was more of a general comment, I think that in this day and age, and these ongoing discussions of free, prior, informed consent in today's world, which always should have been the consideration and the discussion with tribes, that it's important to acknowledge and incorporate acknowledgement of tribal laws, and how the tribes deal with repatriation and these sacred matters. Thank you. And I'll bring the others up as we head into definitions.
Okay, thanks, Honor. I do have I wanted to actually give Melanie a chance to respond regarding the issue about the review committee being provided information regarding prosecutions under or investigations under NAGPRA. I know she's mentioned it in a number of instances, the new hiring of the civil penalties investigator. And I just wondered if there is some prohibition about talking about particular cases. I can imagine at some points there might be, in terms of what information is shared and things of that sort. But Melanie, do you have any comments you want to make on that? It seems to me to be logical that if information like this was to be shared with the review committee, it would come from the National NAGPRA program as opposed to some other authority.
We provide information on civil penalty allegations in our annual program reports. In general, again, I'll just remind the committee that information shared with the committee is public information. And we don't often share specific information with the public on investigations.
Melanie, I think this is more also a matter of numbers. For instance, what is the longest time that a failure to comply complaint has gone in? Has it been a year, 10 years, 15 years versus the shortest? What are the numbers in between? How many of these investigations have not been done yet? I'm looking more for numbers and not details of what the specific issues are that have come forward, and that would not interfere with an investigation. I'm looking for the numbers. Thank you.
Well, we have in the past provided pretty detailed numbers in terms of the number of allegations that have been received, the number that have been investigated, the number that were found to be substantiated, the number that were found to be unsubstantiated. I would refer you to the 2017 program report for that kind of specific information. And then other more detailed information is provided in reports previous to that. In terms of the timing, investigations vary greatly depending on the facts and the complexity. So I can't really respond to your questions on timing.
Okay. Melanie, should we move on from, or rather Honor? Tim, you got a comment?
Just as a follow-up to that, I know that at the February the 2nd hearing with the Senate, the chair of the Senate Indian Affairs Committee was very focused on the numbers and asked specifically about whether there was a backlog. And the associate director for the Park Service said that she would be getting that information back to him. I agree with Honor. The numbers, the raw numbers do not impinge on any investigation, but it does provide us with a better understanding of whether there is a backlog, whether there are allegations that are not being investigated. And then that gets to the whole issue of what resources might be necessary to fulfill that task. And that is something that is on our plate for dealing with our report to Congress. So we've asked many times for those numbers. And since 2017, we've not gotten them. But I think we should keep on this.
Thanks, Tim. Okay. Honor, have you got your at least your initial comments taken care of with this exchange, and we'll keep moving through the.
I'll bring up the other one. Thank you. And we hit the other sections. Yes, I would like to see some follow-up with this at our next review committee meeting. Also, Tim had mentioned that this will be reported back, and I hope that the review committee can also see this. I think it's important for the public to know. I think it's important for the tribes to know. I think it's important for the people who have brought forward allegations to understand and know whether it's being looked into or not. And if there's a significant lag, then I also think that's something that the review committee should take under consideration and report. Thanks.
Thank you. Thanks, Honor. Okay. Okay, then with that, we will continue going through the document. Next comment again back to subpart A, section 10.1. Shelby, you had a pretty detailed comment on that. Do you want to describe that for us? And if there's a specific recommendation, maybe identify what it would be.
Yes, I think I've already, I think, covered that in terms of having something in the purpose regarding reference to the act.
Oh, okay, I see that. Yes, I'm sorry.
Yeah, and then I think part of what you were discussing earlier in terms of disposition and repatriation to whom, in terms of lineal descendants and tribes and so on, that seems to be have been left out of the purpose as well. So
Okay,
I think you've already pretty much covered that. So
okay, thank you. Thanks very much. So I will try to get back to those in terms of the redraft of something that I promised in our last segment there. Okay, introduction. Section 10.1, the introduction, duty of care. Frankly, I guess this is a question more than a specific recommendation, I think. And so Melanie, perhaps you could help with the answer here, but and I think we actually talked about this a little bit back in August when you went through the important sections of the sections you thought were particularly important of the revisions. And so the reference to 36 CFR Part 79, and for those of you who don't have that particular reference memorized, it's the section of the Code of Federal Regulations that describes how archaeological collections that are the care of which is the responsibility of federal agencies are to be cared for. And it deals with a variety of different kinds of curatorial activities, from inventory to what kind of environments things need to be kept in, to how and what kinds of uses those collections may be put to. And as you can see, I've got a number of questions about how that gets, what's envisioned for that as part of the care for and management of the duty of care, and how one can require as a regulatory document that museums, for example, that do not have archaeological collections of federal agencies that they're currently curating for, or that they're currently curating without being acknowledged by agencies that are responsible for it, can be required to respond to those requirements that are in a federal code based upon, not based upon NAGPRA, but based upon the Historic Preservation Act, at least sections of the Historic Preservation Act, the Antiquities Act, and the Archaeological Resources Protection Act. So it's a question.
To me,
For you, well, unless you want to pass it on to Brady and Stephen.
no, I can respond. First of all, let me clarify that I wouldn't speak to a vision or envisioning. The text of the regulation should be taken at its face. And I wouldn't want anyone to think that there's some interpretation that can be provided beyond the plain language of the regulatory text. So to that end, I would note that the reference to 36 CFR only pertains to federal agencies in the draft text. So that kind of addresses your second question.
Okay, I guess I better go back and read it more carefully.
Well, it says the regulations require federal agencies to care for and manage all cultural items, ... consistent with 36 CFR 79. The second sentence addresses museums to safeguard and preserve all cultural items under its control.
So that reference to 36 CFR 79 and does not extend into the second sentence, is what you're saying. Different function, and exactly what, and I think so. I think one of the questions I had was, what does safeguard and preserve mean?
The safeguard and preserve would mean what the dictionary says safeguard and preserve means.
I'm sorry, not picking that up. What is it intended to mean in this, as it's used in this section?
It's intended to mean what is in a regular dictionary in terms of safeguard and preserve.
I think there's probably a variety of definitions in dictionaries about safeguard or preserve. And so in this case, since you're requiring, so in this requirement, which is new requirement, not in the original regulations or in the statute, not that it's unimportant, but typically if there is some sort of like a standard museum term that has the definitions, that's used within the discipline or within the profession, there's something like that. But if you're just using dictionary definitions, there are lots of them. So again, maybe it's not envisioning, but I guess maybe I overspoke, but what is the meaning, I guess, was what I was getting at of this. I recall when we talked about it in your as part of the discussion around your presentation in August about this particular section, everybody kind of nodded their head and said, oh yes, that duty of care, that's important. But it needs to be clearly understood by the organizations that are going to be responsible for the duty of care, what safeguard and preservation means. And if you think if a dictionary definition is sufficient, I guess that's the case, but I'm just asking whether it is legally sufficient and what is the basis for that in implementing the law.
Perhaps this is a good moment to ask Brady to join us and comment on the legal sufficiency of plain language interpretation.
Thanks, Melanie. I want to harken back to a point that was made also back in August about the legal sufficiency of the rule as presented. The solicitor's office has reviewed this rule. It reviewed the rule before it went public and signed off on it in terms of legal sufficiency. I appreciate the question here about, I guess it's a question of authority about how the duty of care can be applied. The solicitor's office, I don't think, had any concern with whether there was an authority within the act to describe the process and how that might play out, including how museums might be obligated to care for human remains, cultural items throughout that process. But of course, what we didn't weigh on is the more practical substantive side, which is really the charge of folks like the review committee and experts that the department works with as to what that standard of care should be. The terms as they're used right now are undefined. To the extent that regulations contain non-defined terms, then they would have their standard dictionary meaning, standard common use. And I think that's the point Melanie was trying to describe earlier. If the review committee wants to recommend a more standard definition, or it wants to recommend specific types of duty of care, either for federal agencies or museums, or for both, those would all be perfectly acceptable recommendations. The underlying question as to whether the department has the authority to implement that, that likely depends on the scope of the recommendation, what the duty of care is, which I think is why you see two different duty of cares applied in the existing rule, where their authority will be different in terms of how it applies to a federal agency versus a museum. But that's depending on the scope of that duty, it's possible you could find out what might apply to both. You could recommend that or recommend varying versions. I think there's a lot of options there. but would love to defer to the review committee on its input as to what an appropriate duty of care would be.
Okay, well, thank you. I appreciate that. I think it, well, I guess this would be the sort of thing that people that work in museums that are caring for items that are covered by NAGPRA would be, might have some questions about what's this, is this a new responsibility, or is it just something they're already doing? So maybe we, that's another reason for reaching out to that, to those kinds of organizations or agencies for that matter, which also already have these responsibilities for collections that include NAGPRA items that we should be doing, that we should be looking for. So I appreciate your comments. Shelby.
Yeah, just to add to that, the American Alliance of Museums has lots of information on the standards of collections care and so on. And, museum staff have a lot of responsibility for caring for all collections, not just NAGPRA collections, but there are various standards that we all follow in terms of caring for our collections and having the appropriate facilities and HVAC systems and so on and so forth. So I think a lot of those standards, I mean, they exist already in museums who are serving as repositories for collections. So and working with federal agencies as well, if you've got federal collections under your care. So and I think more recently a lot of museums have been working with tribes through consultation, NAGPRA consultations, to come up with set policies that are much more sensitive to NAGPRA related items, cultural items in their collections, as well as human remains. So I think a lot of museums are moving forward with creating policies specific to the sensitive care of NAGPRA related materials. So, but yeah, there's already there's a lot of standards out there right now specific to care.
Shelby, since you mentioned that, thank you, and thanks for those details. Do you think there is a particular standard that would be most appropriate in this instance that might be referred to as opposed to safeguarding and preserving?
There are some museums that already have established policies regarding the care, and especially the sensitive care of sensitive items such as NAGPRA related items in their collections. And those have, a lot of those have been put together through consultation with tribes. And there are models out there. And so I think, those we could work to identify some of those models and make those somehow available, possibly to museums.
Thank you. Honor, you have a comment?
Thanks, Frank. I feel like this section also should have a lot to do with consultation with tribes. And I'm speaking also generally here with regards to standards of care. I mean, in the past, I think we've all heard of the horrific circumstances where our Indigenous ancestors have been mistreated in museums, where our people are thrown about in boxes, stuck in loud areas, waiting to come home. And this also happens with our spiritual items. And I think that this is a broad discussion. It's an important discussion that really the tribes should have significant input on, about what those standards of care should be within the regulations, but also in each instance. And certainly my hope is that this is avoided in the future and throughout the repatriation process, because our ancestors are human beings. And it's important that the review committee and museums and federal agencies keep that in mind, that there are people, our relatives. So with regard to a standard of care, I think it's important, but I think primarily we need the input of tribes. Thank you.
Thanks, Honor. Tim, and then John.
I just went back to the original, there's text in the draft, and I think I sort of see the source of an ambiguity there. That said, that section C reads, these regulations require a federal agency to care for and manage all cultural items in its custody or under its control, consistent with the regulations at 36 CFR 79. And Frank, would you agree that is a true statement?
A true statement in the sense that that's how
The care of the collections, that 36 CFR 79 would apply, and federal agencies would need to comply with that.
yes.
And then I think the source of the ambiguity.
The only potential problem with that is that if there are cultural items that aren't part of what's termed an archaeological collection, that might mean they would not be cared for in that way. But most of these items are probably going to be archaeological collections, as opposed to donations or something like that, for which the original context or provenience is completely unknown, something like that. So by and large, yes, I think that's true.
And I understand that that's a fine distinction that I think is valuable here. For the objects that are not part of archaeological collections, that would normally not be under 36 CFR 79.
Correct.
And I want to ask Brady and Stephen, can the department, by this regulation, by 43 CFR 10, extend the provisions of 36 CFR 79 to this additional class of items? And that's just sort of a, can you do it by regulation, by this regulation?
We would interpret the application of that part to items in non-archaeological collections differently. That it's not an extension of Part 79, but that it is in fact a distinct obligation under NAGPRA and under the Secretary's authority to issue the regulations under NAGPRA that uses Part 79 as a standard. So we're pointing to it much like you were throwing out examples of pointing to maybe like AAM standards of curation, using those as reference points to fill in a duty of care that we might want to require. Now that said, again, we'd be open to recommendations on ways to make that clearer or hone in on the specific requirements, or if that was an overly broad reference point, if there are parts of Part 79 that you think are inappropriate to apply here, we could be more specific, or you could recommend throwing it out altogether. My point being, it's a reference point that we are using to create an obligation for this regulation, not to extend a regulation under a separate authority.
But in effect, is not this language doing that?
It has a similar.
This language talks broadly about all cultural items, not all cultural items that are also part of archaeological collections.
Yeah, I'd agree with you that it has a similar practical effect, but the legal mechanism for doing so is technically different.
Is there some
I
way
would
we
note
could
also, I would
rephrase?
note also that I'm sorry, Tim, but I would note also that the regulation says consistent with the regulations at 36 CFR Part 79, not as required by. Those are two very different things.
Is there some way to rephrase that provision, the first sentence, to capture this nuance?
There may be, as Brady has said, we would appreciate the committee's recommendation on that.
So Frank, I actually would recommend that for this particular one, if we would recommend that the department clarify that distinction between federal agency archaeological collections and federal agency other cultural items that are not part of archaeological collections, and how that works. Does that sound fair?
Yes, I think so. I think Stephen would even welcome some specific language that we might suggest, although I think pointing out the potential problem might be as much as we need to do, and just ask them to take a look at it and figure something out to eliminate any potential problems for using that kind of phraseology.
Right, and to follow up on that, continuing on with that section, it then says these regulations require a museum to safeguard and preserve all cultural items under its control. And I think the actual source of ambiguity there is those first two words, these regulations, which I suspect what was intended is these regulations refer to 46 or 43 CFR 10. But the fact that it occurs immediately after reference to 36 CFR 79 creates some ambiguity there on what the meaning is. And I think in our discussion, and I'll ask Brady and Stephen again, can by regulation, we require museums to follow 36 CFR 79 for their collections, for their non-federal collections? I suspect the answer is no.
Brady, go ahead.
Yeah, we cannot extend 36 Part 79 to museums that are holding a collection. In theory, an agency could maybe use parts of Part 79 to define a new duty of care that it could build out here. The department chose not to do that in this case, like list out, copy paste some ideas into a new section or something like that. Theoretically, that could be something you could do, and it could track the way Part 79 works and be proposed as part of this regulation, for example. That didn't happen in this case, where instead the duty of care was left more generalized, I think open to the interpretation of the museum community, and thus might be ripe for feedback from you all about if there's better ways to interpret what an appropriate duty of care would be for a museum.
Thanks. Thank you, Brady. And Tim, yes, go ahead. You're muted, Tim.
Right. For that second sentence, I would propose that we recommend they remove the phrase, these regulations, because that creates part of the ambiguity, and say something more like a museum is required to safeguard and preserve all cultural items under its control. And we need to figure out what the end of that sentence would be, according to what?
Okay.
Because we can't rely on 36 CFR 79. What can we rely on or recommend? Or maybe one of the issues is whether they are required to do that or whether they should do that. I don't.
And I know John had a comment, and I want to hear what he had to say. But that was actually, one of the questions I had with Shelby was, is there a discipline-wide standard there are individual museums that have standards, maybe even regional museum organizations that have standards that might be referred to. But John, as a curator, you know of discipline-wide or some kind of officially accepted set of standards that we might recommend be referred to here?
I go back to what Shelby said. A lot of the things that she had recommended tend to be what people would, I guess, in the profession would go by and acknowledge. Now that being said, now there's what we're looking at here, and just as a curator, somebody who works in museums. So then I guess also looking at this duty of care, and as we're thinking about where we are in the regulations. To me, I see the word all in there a few times, and going back to perhaps the intent of the law and where these regulations are supposed to take us. When you work with when you work with museum collections or anything that's in your collections, you're supposed to treat, I said, the collections and perhaps everyone or everything that's contained in that equally. And this duty of care, I mean, is it acknowledging, and that was one of the questions that I had. And so when why should, if one subset of say items or collections that as they sit in a museum or repositories collection, are you looking at that not everyone is getting equal curatorial care? And if we look at this duty of care, in the museum, you have a responsibility. We have a responsibility, whether you view it as sort of you're in the role of stewardship. If you want to look at it that way, but really when this says these things should be applied to all cultural items, shouldn't everyone's cultural items be represented or cared for equally within a museum's collection? So if we're going to say, and that's not to, and I'm certainly, and it's applaudable that museums place these importance on treating, I say, like the ancestors of these descendant communities in a very sort of respectful way. But when we're talking about progress, we're also acknowledging that in the past they weren't, and why, and why weren't they? And so I go back to, it's not, haven't talked about it certainly a lot, but this, and over time, this is, I think I've talked about with other people, not just in terms of let's say the curation or care of collections, but also as the descendants or as people exist in these collections, the remains of all people exist in these collections. And I go back to a part of my own training, and it was back in college when I was in a gross human anatomy course. And it was like day one when you're actually going to be studying, and and it was I had a great takeaway from that, and I tend to think about that when we think about the care of human remains, is that what was required of us as students was a great respect for those that we were studying, those that had perhaps donated their remains, their bodies for the advancement, if you want to call it, of science. And to be honest, there was no mucking around there. We weren't to be insensitive to those individuals or make insensitive comments. And the very real threat was that if we engaged in that type of that type of behavior, that we would fail the course. And that's something that has stuck with me, not just working in this field or as we sort of our interaction with human remains. And so I've carried that forward, and with the experience of and it's not I'm not here to call anyone out, but as we say, and as I mentioned earlier, it was to, and some of our the comments we do hear from the Native communities is that there is that type of care that's still existing, or there's a feeling that it's still very disrespectful. And so I said, I go back, at least for me personally, to that experience in that particular course, is that there were very real repercussions, and that told me that there was a great respect for that, which we had the opportunity to learn from those individuals. And so I won't say but you do carry that forward as we look at this duty of care, is that this everyone should be treated with that type of respect. Those individuals, or the collections, those collection materials or items that represent those cultures or those peoples.
Thank you, John. That's an interesting personal example as well. I have to say, my sense was, when I was dealing with human remains from archaeological contexts, really the same kind of standards applied in the projects and the programs that I was part of. So, but we do know there are other examples where there's less care, less safeguarding and care or preservation. Any other comments on this particular matter? So it does seem that there are some recommendations we would make here regarding those that particular section, at least, duty of care, about if not definitions, at least clearer language that would make certain things less ambiguous. Tim, yes, go ahead, and then Honor.
Just one last thing. Given the way that the section on civil penalties has been revised to sort of say it's a violation of, or it's a failure to comply if you violate any of the requirements of the statute or any requirements of these regulations, this safeguard and protect, or whatever the language is, without any specification, without any CFR reference to it, just opens it up. Because if you're sort of leaving it to the civil penalty determinator, the investigator, to determine whether they have complied with this or not. And it's just two words here that we have not defined. And it has big liability for museums. So I think we need to make sure that this is very specific.
That's a very good point. Honor, you had a comment also, and then Shelby.
Yes, thank you, Frank, and to all the committee who's commented. I believe, from what I understand and looking at the transcripts of the consultations that were online with the tribes, they seem to be very guided consultations. I wonder if we can do a running list as we talk through things of specific items that the review committee is flagging for a potential, and certainly it wouldn't be all inclusive, but for the Secretary of Interior, in case there is a second round of tribal consultations. I feel like this is an important discussion. And with regards to standards of care, we're talking a lot about museums, but tribes, and I imagine some tribal laws also have this integrated into their tribal codes, and certainly the traditional laws of tribal nations. And these are also important considerations. I am concerned that we don't have a better definition for this. But again, I think these are important things to flag, because we're under a duty to consult as well under NAGPRA with the tribes and to hear from the museums. So thank you.
Thanks, Honor. And specifically, when you refer to the tribal laws and tribal methods, you're talking about what's meant by duty of care in terms of
Yes, with regard to duty of care, and as Shelby had mentioned, there's an important consultation process that takes place in repatriation. And I wonder if the tribes have a recommended duty of care that should be used. I'm a little, Tim, I was wondering if maybe you could read out the duty of care that you had referenced as well, so that the committee could hear it.
I need to find it. Give me a second.
Thank you.
While you're finding it, Tim, we'll see what Shelby has to say here. Shelby, why don't you go ahead?
Thank you. I think when I first read this, I was a little confused because I thought it was just, I think there needs to be probably a very first sentence in this that it's referring to the care of cultural items by museums, federal agencies, and now with what Honor was talking about, and maybe something about in tribal communities as well, or something, because when I first read this, I thought, well, the first line is referring to federal agencies, and now I clearly understand it's also referring to the regulations, 36 CFR 79, which doesn't apply to museums. So that's where I was kind of confused. I was like, well, you need to be talking about museums and federal agencies. So I'm wondering if maybe just an introductory sentence there referring to museums and tribal and federal agencies or something, just for clarification. And then you've got the federal agencies, then you've got the museum, maybe following standard, AAM standards or something like that, that we can kind of rephrase that a little bit so it's a little clearer. Anyway, I just wanted to point that out. That was part of my comments.
Thanks, Shelby. Thank you. John, you have a comment?
Yes, and so I want to again thank you, Frank, and thank Tim. I mean, at least for the discussion on because for the clarification there, at least teasing out those two components, those two pieces, moving pieces there that are in that definition, because it's not, while it refers to the 36 CFR 79 taken together, it's can be read as somewhat confusing, that you're or what's sort of falling under this duty of care. I mean, we're sitting here, going back and forth on it. So imagine, again, going back to what I said earlier, trying to move from point A to point B. And if you see something like that, that's not very clear in its certainly in its distinctions. So that's my comment for right now. So thank you.
Okay. Thanks, John. Tim, we don't have an awful lot of time left to continue this discussion, but Tim, you were going to look up the actual wording, I think, in the proposed revision. Not sure how much time we'll have to discuss it further. It does sound like we have recommendations.
The duty of care section says these regulations require a federal agency to care for and manage all cultural items in its custody or under its control, consistent with the regulations of 36 CFR 79. And I don't know how to tweak that to cover the non-archaeological collections, but I think we can think about that. And then the second one, I would propose something along the lines of a museum is required or should, which is a big distinction, and we'll have to think about how far we can go, to safeguard and preserve all cultural items under its control according to something or consistent with some standard. So we have to figure out what that standard might be.
Okay. So That's John. Go ahead. Yes, you got it.
Thank you, Frank. And so I guess I had a rethought on this standards of care or duty of care. Sorry. And so my question for how this sort of becomes introduced into this new draft of the regulations, is it in some ways based upon perhaps the NAGPRA office has heard, certainly concerns from the tribes, particularly in terms of, you want to say the archaeological collections, if we want to talk about a standard of care, who over the years have said when they go and visit some of these repositories that they're really appalled at the way the ancestors or the archaeological collections or those components are housed and stored, really still in paper bags and buckets and things like that. And I think those are comments that either we've heard locally or I've heard in some sort of form in the public comments from the tribe. And so is this duty of care, as I was saying earlier, is it raising it to some sort of standard that if you're going to be caring for these collections, they shouldn't be, the ancestors shouldn't be in paper bags and in buckets. So is this sort of, I guess that's a question too, is this sort of in response to that, this duty of care to sort of at least make a first step to acknowledge, I think what we would all, and I guess from a curatorial standpoint, that's not an ideal way, even, to be caring for those collections of that, certainly of that sensitive nature.
Thanks. Thank you, John. Madam DFO, we are 1 minute away from the planned conclusion of this meeting. Do you have any guidance? Can we continue for a few minutes longer, or do we need to?
We really need to complete the meeting.
Okay. How about this then? I actually think once we got into it, the document has helped us a lot to identify some areas where we don't have concerns and other areas where we have some substantial concerns. Not quite sure what to do about those concerns. We've talked, particularly in the last couple minutes, about very specific recommendations to the secretary, to the department, about a lack of clarity or potential confusion about what the meaning is of ones, and we might even have some specific text to suggest. And in others, we've kind of affirmed some of our earlier concerns or comments about amount of time available, availability of information, things like that, and then some specific things about communication as well. I've got a couple pages of notes on that I could try to put together and share with the individual members of the committee, and then as part of our picking this topic up again, we could discuss them in a public setting at the next review committee meeting.
I might make a suggestion. That
yes,
he has a
Madam
pretty
DFO.
good model in terms of how it makes written recommendations through the report to Congress. I would encourage you to take up that kind of a model here in making your recommendations. For example, it's not really a recommendation to say that something is unclear. A recommendation would be how would it be clearer? What information should it have? So I think that if the committee can focus on making those kinds of recommendations, it will have more impact. And if the committee could focus on, I don't think that a document needs to be as limited as perhaps what you prepare for Congress, but I do think that clear recommendations should be the goal. Clear stated recommendations from the committee as a whole. I think the document is useful in that it provides a lot of your individual comments and concerns, but where I have trouble, and I would say the department would have trouble, is understanding what the committee as a whole is recommending.
Madam Chair, that might be a good model for us to go back to. So it would require some drafting offline, so to speak, and then again, probably compiling together specific comments into another document that we need to discuss at the next meeting or in a subsequent meeting, so that it's part of our publicly developed recommendations. So I could take the notes that I have and write them out and pass that around to the other committee members for people to take a look at. I guess instead of setting up a separate committee for regulatory recommendations, we'd be operating as individuals, like we did putting together the working draft, and we could consider this yet another working draft, and then come up with as complete a set of recommendations as we can to talk about at the next meeting. So if I did that and got something out by the end of this week, say by Friday of this week, and then give committee members till the middle of next week, and then I pulled something together for us to put up on the meeting materials page. How does that sound to other members? You can, okay, Shelby, got a thumbs up from Shelby and Tim. John's nodding, Honor's nodding. Barnaby's, thanks Barnaby. Also, okay, so by the 18th, I will try to get something around that approximates what Madam DFO has suggested. And by the 23rd, Wednesday, your individual comments back to me, I'll consolidate them and then I'll send them to Madam DFO for putting into the materials by the 25th, early on the 25th.
Just a reminder that there is a disposition request on the 28th, as well as a presentation.
There's a presentation and a disposition. Yes, I see. So we're not going to have as much time, but we can't schedule another meeting. So we'll see how much we could get done, because I mean, we've gotten through about 5.5 pages. No, 5 pages at this point. So that's actually not bad work for the first day, the first 2 hours actually of discussion. But we need to keep moving along on it. So okay, so if that sounds okay, and I saw the nods by everybody, so we'll move forward with that idea and see how we can do. And with Madam DFO recognizing and reminding us of the timing, we'll try to keep moving apace.
It's also a reminder to review the materials for that disposition request.
Yes, yes. So, so Madam DFO, do you have anything else you want to bring up, or other committee members have anything else? John, your hand is still up, but I think, okay. Madam DFO, anything more?
No, I would just state for the record that we had no requests for comment. I solicited again public comment as you were discussing and received none.
Okay. Well, again, also, I want to encourage representatives of tribes or tribal organizations, museums, scientific organizations, federal agencies. If you've got some comments, please send them to the National NAGPRA program and on to the review committee on this important matter. And we would welcome comments very much. And I think I want to thank Madam DFO and the National NAGPRA staff. I want to thank each one of my fellow members on the committee for your attention to this important issue. Brady and Stephen as well for their advice and focus. And Madam Chair, do I close the meeting or do you?
I will adjourn the meeting. Thank you.
We are adjourned. Thanks, everybody. See you in 2 weeks, but we'll be in touch. Bye-bye. Have a good couple of weeks. Happy Valentine's Day. Take care.